Oh, it's reassuring to hear the tune of Perry Mason back where it should be. The old television lawyer theme to introduce David Whiting, our talkback lawyer. 1300 222 774 if you need some free legal advice. David, enough of startling people with newfangled themes and the like that Ms Trioli seemed to think she could foist upon an unsuspecting public.
Well, I'd never heard of the tune before, John, with some embarrassment. But the lawyer who I, when I was growing up, thought was the best lawyer on television was, after Perry Mason, was an American thing called Petrocelli.
Yes.
Although he's a great lawyer, but I have none of his handyman skills. So let's not go looking for it, John. Let's stick with this one.
You could work on that. Now, there's a couple of important things that have happened in the Victorian legal system in the last week or two. First of all, in a most unusual step, the coroner has announced that, the chief coroner has announced that someone's made a complaint about her to the Judicial Commission, which is the watchdog over judges. So she's taken herself away from the coroner's court, gone back to being a county court judge for the time being until the matter's resolved. This is quite remarkable. What do you make of it?
Well, I think it's perfect. I think it's the system working the way it's supposed to work, John. I mean, we've always had criticism for years that judges were not capable of being criticised. There was no oversight body. There was, once you were appointed, you needed a resolution of Parliament to remove you. This is a system that's working. So the coroner is appointed as a county court judge and then appointed the coroner. And so she is a county court judge. If the issues relate to the management of the bullying allegation at the coroner's court, then it's appropriate that she not do that. But it's also not appropriate that she should not do anything. So she's gone to the county court where she will be assigned other work.
Now, my understanding, I don't know how much digging you've done on this, but just chatting to people even in the time since I've got back from holidays, she's trying to introduce some cultural change to the coroner's court, which has had established work patterns for a very long period of time. And not everybody's happy with being asked to change the way they work. And that's resulted in part, the substance of this complaint. Now, we've seen this in many other workplaces too. People make a bullying complaint, and that's a very serious matter. But sometimes, in fact, all that's happening is they're being asked to change the way they go about doing their job.
And that's what this will show, John. I mean, yes, it is often a response. Your bullying allegation is made because somebody wants you to do something different.
Depends how you ask, I suppose, doesn't it? If you shout at people, if you are aggressive in your engagement with people, if you're making them feel that they're not being respected,
they're not valued or they're diminished as a result, that's bullying as I understand it to be. But I would have thought it was up to the organisation to determine what the work structures and flows are, since it's a management decision, not an individual operator decision. But all I know is what I've read in the paper, John.
All righty. So other legal issues, other legal developments?
Well, there was an interesting case in the Supreme Court last week, in the High Court last week, which will have an extraordinary effect in relation to the concept of procedural fairness. And in that particular case, the judges decided that a self-represented litigant was entitled to start his trial again. He'd run a matter in the Supreme Court of New South Wales in an argument over a will. He was not represented at the hearing. He wasn't well prepared. There were arguments about how much time he had available to himself, and he lost it before the single judge. He then appealed to the Supreme Court, full court of the Supreme Court of New South Wales, Court of Appeal, and he was totally unsuccessful there.
Representing himself again?
Again, representing himself, and then went to the High Court, and I can't tell you whether he was represented there or not, but he was successful.
Successful?
He was successful on the basis the court found in a short judgment that he was denied procedural fairness and that the matter ought to go back to to a single judge of the Supreme Court of New South Wales for the matter to be determined.
So does this change the rules then on how judges have to look after someone who chooses to represent themselves?
I think it does. I think it imposes a greater obligation on the court to support self-represented litigants.
But the judge can't, on the one hand, be your assistant and on the other hand, be the decision maker.
No.
So
that's the problem.
It's a huge problem for the courts as more and more people find they can't afford lawyers, they're not eligible for legal aid, and they choose to try and do it themselves.
So what you might end up with is the procedural fairness runs the other way, is that the judge, through bending over backwards to provide procedural fairness provides assistance above and beyond.
And then the other party appeal and say, well, now actually the judge was running interference for the self-represented litigant. We didn't get a fair trial. It would be much cheaper and simpler for everyone if you, in fact, properly resourced the legal aid system to help people.
Yes, it would.
In the way it was originally designed to do.
Well, we know from experience, John, that self-represented litigant matters involving self-represented litigants take a lot longer than ones where both sides are adequately resourced and present their cases.
The courts are constipated because of self-represented litigants clogging the system up.
Yes.
And it's a disaster for everybody. All right, well, let's see. Anything else before we move to today's callers?
We had a couple of bits of homework, John. We had Rick from Euroa, who was calling about unauthorised flows from one property to another. And in that particular case, there were just, when it rained, the water flowed. And so the question then becomes is who was responsible. I told him that I would refer him to the particular provision, which is Section 16 of the Water Act, and allows a suit to be commenced against a person who causes a harmful flow of water from one land to another. And I had a discussion with a client on this matter back in April, but the answer is that a new cause of action arises every time it rains. So instead of simply saying, oh, well, it's been going for 20 years, doesn't matter. Every time there's a new flow, there's a new cause of action. Ted from Genoa called down in Gippsland. A friend of his was picking up hay in Ercildoon near Ballarat, and Vic Roads have complained about loading hay on the road.
Loading hay
so,
on public roads?
Yes.
What, with forklifts and the like?
Well,
or tractors?
Or a tractor with that can take the hay bales or the big rolls.
Yes.
And the driver had been threatened with proceedings if that process continued. Vic Roads complained. The council said we don't care, provided everything's okay. But if you actually look at the Road Management Act,
well, if someone gets hurt, for instance, then yes, you've got a problem.
Well, the problem, John, is that not the problem is that that Vic Roads have prepared a whole series of traffic management plans. And if you're undertaking work on a road, then there is a code of practice for worksite safety-traffic management that you need to follow, but you require flagmen, you require cones, you require a whole series of things that you probably don't want to pay for half an hour. So that's the problem. Someone's got to work out what the compromise is.
We don't take questions by text message. But I've got this one that I think is important. It's someone who says they're asking for a friend.
Yes.
I gave over $1 million to my own political party and haven't got value for money. Can I get my money back?
Well, can't you claim a tax deduction for donations to political parties?
I don't know. But the wit is overflowing. David in Berwick, you're first with David Whiting, our talkback lawyer. Good morning to you, David.
Oh, good morning. Thanks very much for taking my call. I'm actually calling on behalf of a very good friend of mine. She's quite distressed at the moment. She wanted to get a deck and a decking built on the back of her home and also have a retaining wall rebuilt. She engaged a guy that, I don't know, she found an advertisement for somewhere. He came out, he quoted the job. It was just over $15,000.
Yes.
Paid him up front. He said he wanted upfront payment so he could buy the materials and everything else.
Yes.
So she did that in good faith. The works commenced and she was sort of quite concerned about the quality of the work that she was seeing, just the way everything was lining up and unevenness of stuff. And she happened to know a qualified builder, so she invited him over and he had a look at it and walk her out the back, and there were stumps for the veranda and he literally kicked them out with his feet.
Yes.
And said, oh, this is just a joke. Who is this guy? Anyway, they arranged a time for her friend, the qualified builder, to actually attend on site when this fella came back.
Yep.
And had a conversation, and again, the builder sort of set this guy in the right direction, and basically said, "Look, this is what you need to do, mate. Come on, get it sorted."
Yes.
Works recommenced. The builder went out there again and had a look. Again, he was able to kick stumps out. He walked up to the retaining wall posts and literally pulled them out with his hands.
Okay,
Yes.
We've got the picture. The work's substandard. What's your question about what to do, though?
Well, my friend decided that she just couldn't trust this guy, so she basically told him to forget about it.
Yep.
She had the works built by someone else, and now she's got an issue of getting the money back.
How
from the
much
other guy.
money did she pay in advance?
Over $15,000, and it turns out...
So she paid the full quote in advance?
Correct. And the other kicker in this is it turns out this fellow is not actually a registered builder, so he's actually not qualified to have taken on this size job.
You need to look carefully at what the job comprises, because not all of it might be building work. I mean, my guess would be that the deck constitutes building work under the domestic building legislation, but it's unlikely that the landscaping did. So the retaining wall is unlikely to be. You need to look very carefully at the Building Act, and the Domestic Contracts Act. But you need to make sure, because if it's not that amount of money, then the same provisions don't apply. So her difficulty is she needs to go to VCAT. She needs to she needs to pay for something, because presumably some of what he did can be used. But she needs an order that he's entitled, that he's obliged to give her a refund. And part of the argument with VCAT will be how much is it worth, and she'll need her friendly builder to provide advice as to exactly what was wrong with what he was doing and why it didn't comply with any of her obligations.
All right, I hope that helps you. More calls in just a second, but in more breaking news from the national capital, and I might say the comedians and the wits are having a great time with the result of the ballot today. In more breaking news, Malcolm Turnbull wins the first poll for a very long time, winning the leadership poll within the Liberal Party room. And thank you to Darwin for that. The Northern Territory News. Breaking news, Malcolm Turnbull wins his first poll for a long time. Oh dear. There's going to be a bit more of this, I can tell. Greg and Blair Gowrie, good morning to you.
Good morning, John and David. Thanks for taking my call. I've just got a query around what the responsibility / liability of the council would be for trees which during recent high winds have fallen from the nature strip over a front fence and damaged it, and obviously there had to be a lot of work done to clear it and so forth. Just if you could give me some advice around that, I'd be very appreciative.
It may be that the council has no responsibility, Greg. There's a piece of legislation called the Road Management Act,
right,
that we talk about from time to time, and it sets out the responsibilities of road authorities.
Mm-hmm.
And there's a concept of what the law calls non-feasance and a concept called misfeasance.
Right.
So, and it's the difference between doing something badly and allowing it to happen.
Mm-hmm.
So it arose from a case, the particular Road Management Act about 2004, arose from a High Court case in about 2001, 2002.
Right.
And it concerned the council's obligation to maintain a running track. You know, the running tracks you get by the river?
Yep.
And every now and then the trees grow and the roots come up. And the question is, it was the responsibility of the council to make sure that the roots were always covered and we properly maintained the service of the track.
Which would be practically impossible to do.
Yes, and if you go back 300 years, the issue is, as you know, you're riding on the top of a stagecoach from somewhere to London, and the question is, does the council have an obligation to make sure the trees are trimmed so that your hat clears, that the branches from the overhanging trees clear your hat? So, so we talk there about non-feasance, things that happen. The trees grow, the roots grow. There's general deterioration over time. We don't hold the councils responsible for that. But the other thing is called misfeasance, and that's the situation where, for example, the council digs a hole and inadequately signs it, as a result of which you drive into it. That's called misfeasance.
Because they dug the holes.
Because they dug the hole.
Did something
they had an obligation to do it properly.
Yep.
So I would be asking council what they're going to do about it, but I would also be asking council when was the last time they conducted a survey of the trees in the street? Because my view would be that a proper maintenance plan would involve an assessment of all of the things that they own in the road reserve.
Greg, was a car damaged or did something actually happen?
Landed in someone's front yard.
Yeah, but was anything damaged?
the fence was smashed, basically.
Okay, well, household insurance may well cover that.
Maybe. I haven't...
And that's what it's for. That's why you've got insurance for those sorts of events, okay? Would be a lot easier to claim on insurance than to try and fight the council, don't you think, David?
Oh, absolutely.
Yep. Alrighty. And let's hope that gets you the result that you need. Sue in the city. Morning to you, Sue.
Oh, good morning. Nice to be talking to you.
Welcome.
Thank you, Sue.
I just have a question. My father passed away last month, and my mother is still alive in a nursing home. Any assets they had were in both names, which was only a house and a bank account. Do I need to put his will into probate, or can I just keep...
He didn't have an asset, Sue. Apart from, the cufflinks and the suits and the personal items, which would be of very small value in the great scheme of things, the principal assets that you would normally get a grant of probate for, the bank accounts and the property, passed to your mother by operation of law.
Okay.
So on that basis, there is nothing in a material sense for which you might need a grant of probate.
Okay, so I can just continue on how things are and...
Well, you sometimes need it, don't you, for bank accounts and the like, in order to convince the bank that you've got...
Well, what happened is that the death certificate will turn up.
Yes, I've got that.
And you take the death certificate. You have your mum's power of attorney, do you?
I do.
You take the death certificate into the bank and you ask them to amend their records.
Okay. Do I need to do that with the title of the house or anything, or that can just stay...
This is the incredibly vexed question that I don't like spending money on, Sue. You need to tell Centrelink that your mum now owns the property on her own.
Right.
That may have an impact on her pension.
Okay.
But you will then need to recognise, and probably will have an impact on her pension because she doesn't live there. But you would need to, in theory, you lodge something called a survivorship application. And that's an application that says, it's made in your mother's name, that my partner has died, the property is now all mine. But it's a process that's, by the time it's all... Well, absolute minimum is going to cost you $150 and might, by the time you've done the attendant paperwork, if you've got a lawyer to do it, might cost you $450. And I come along and say, you don't need to spend the money till you need to deal with the property. Do it then.
Further down the track, and that may be in a completely different context by the time that eventuates too. Okay. And you wouldn't want to spend the money now and then have to do it all again later.
No, there's no duplication. You need to do it then. But I'm saying, for a whole lot of people, the $400 is something that you want to keep rather than spend and give to government and lawyers.
All righty. Greg and Baldwin's next. Morning, Greg.
Good morning. Thanks for taking the call. I'm ringing up about rights of beneficiary of family trust.
Yeah.
In that, am I allowed access to the financial records and the deed of trust?
You are allowed to You are allowed a copy of the trust deed.
Yes.
And you are allowed access to financial reports.
Yeah.
In fact, you have a right to financial reports. As a beneficiary, whether or not they give you any money, you have the right to financial reports, but you have no right to pore over the books of account. Do you know what I mean?
Yes. Yes.
So you can look at the financial statements, but you can't thumb through the checkbook.
Yeah.
Yes.
Yeah. No, that's not a. Yeah, that's basically it.
Yes. So I'm an eligible beneficiary of my father's family trust, and therefore I am entitled to a copy of the trust deed because it sets out what my rights are in relation to the trust, and I'm also entitled to a copy of the financial statements.
All right, Greg.
Okay.
And I'm entitled to make submissions as to why they should give me money.
Yep.
Thank you, Greg.
Okay, right.
And good luck with that. In Blackburn, Andrew, good morning to you.
Morning, John.
Andrew.
Hello from a left winger to a right half.
You're talking about the hockey field, are you?
Yes.
I just thought I ought to clarify immediately, Andrew. People may misunderstand.
Yeah. Okay.
That's because they've never seen him as a right half, I think, Andrew.
Okay. Yeah. Anyway, we'll leave that alone. But
have I been horrible to you on the veterans hockey field?
No, I've bowled you over once. I think that's about it.
Now I know who you are. Thanks for your call, Andrew.
Okay. It probably follows on to the subject. It's a bit of a road rage incident which it was involved in.
Yes.
Where I was punched in the face and my car was damaged by the passenger of the other car.
Oh, sorry. Before we go any further, are the police involved? Is there a court case looming?
No, there's not. The issue is that I lodged a report with the police, and they basically said, yes, we know who the driver is, but the driver's not required to tell us who the passenger is, and so we'll proceed no further.
Yes.
So I gather there's some legislation that says that the driver is not able to be enforced to tell who the passenger is.
That's right. But yes and no. You can issue civil proceedings yourself to force the driver to tell you who the passenger is. So there is a process in the courts that allows for a concept called pre-trial discovery. I have a cause of action against someone. I have an action for damages to my car, to me personally, but I need someone to identify who that person is.
You're going to be spending a bit of money, though, to go down this path. You want to make
absolutely.
sure that, in fact, you're doing it for a purpose that's going to reward you at the end.
Yeah, no, for now I'm looking at all $600.
And the law says, Andrew, that you have to pay the costs incurred by the person you're making the inquiry from. So the issue arose in the Essendon drugs issue, the
James Heard saga.
James, not in that bit, but as part of it, there was a claim made by someone against the football club that says you've got some material in your possession that I could use as evidence for a court case, and I want you to provide it to me. And there was an argument that turned on that point, but the law is fairly clear.
But let's go through, Andrew. Let's say you do find out who it is. What do you do? What do you plan to do then?
I just want to, make a claim against them for the damage to my car. But
which amounts to how much in dollar figure?
Oh, well, I'll have to pay in excess of $600. So, yeah,
Stop.
So if you're claiming on your insurance and all you're wanting to get back is $600, you're likely to spend far more than $600 chasing someone to give you $600. Do you still want to do it?
No.
No, well, you also have another problem, is that you can't resolve the matter for $600. The claim against the person who damaged your car now technically belongs to your insurance company. Yep. So if you got $600, you'd have to give it to your insurance company.
And they will pursue whoever they think may be responsible for the damage, not you. That's how it works. They take over your loss.
So let's say your claim was worth $3,000.
Yep.
Your claim against the person who damaged your vehicle is worth $3,000.
Yep.
You would be required to give the whole of the $3,000 to your insurance company, and they would give you back your excess.
Okay.
All right. Now, it's London to a brick. You're going to be financially worse off.
Yep. I'll just pay my excess.
Yes.
Well, that's what insurance is for.
Yep.
Andrew, that's why we have insurance.
Yep.
So when someone smashed the window on our car in order to rifle through the contents, even if we could have found out who it was, it would not be worth pursuing them. That's why we pay insurance. That's why our premium went up. That's why our excess was whatever it was.
And the police wouldn't take the assault any further because it's fairly minor in nature?
Well, that's up to the police. That's quite separate from your financial loss. So, David, this is a very common misunderstanding people have about why you have and what it means to have insurance.
Well, you have insurance because you can't afford the consequences of not having insurance. You have house insurance. As a society, we don't need house insurance because as a society as a whole, the chances of the premiums are greater than the claims are in any year. Unless your
house burns down.
But as an individual, you can't afford the failure.
Yeah, but the point of insurance is it doesn't put you right back to where you were. It just helps you with most of what you lost, but not every single bit of it.
It won't be. You won't be able to list all of the CDs you had, for example. So you make a claim for contents, but it's a global figure, not a item-by-item basis.
All right, left wing.
Okay, radio, right half.
Good to hear from you, and thank you.
Bye.
And Shane in Templestowe, just getting in with a moment or two to spare. Good morning to you, Shane.
Oh, g'day, John. How are you?
Good, welcome.
Fire away, Shane.
Hang on, I just had to turn my radio off. I had my parents, they sold their house in Melbourne to move to Tasmania with my sister, and they gave my sister $194,000.
Yes.
And they lived there for a couple of years, and my sister sold the house and didn't return the money.
Yes.
But she said to my parents that they could live there for the rest of their lives. But
Yes.
she no longer had enough of Tasmania and she wanted to move on.
So that means that your parents have, there's two parts to the question. If there is a power of attorney involved and there's a failure to properly account, you could go to VCAT or to the Tasmanian equivalent and say she has an obligation to refund. Your other option is that your parents are able to say, our daughter failed in her obligations, in her commitments to us, and we want either a total or substantial refund. Either choice, depending on your particular fact situation. But she's not broken a law by refusing to pay the money. If anything, she's broken a contract she had with her parents.
Okay, cool.
Thank you,
All right.
Shane.
Thank you. Bye.
Good on you, and we covered some vast territory there today, and yet we've still got people who are waiting who we didn't get to talk to. So I guess they might chance their arm at the same time next week.
I hope so, John.
Thank you indeed. David Whiting, our talkback lawyer, helping you each Tuesday at 10 o'clock with free legal advice.